The topic of the conference is social justice and human rights. I will not be specifically talking about social justice and will not specifically be talking about human rights, but what I do have to say is a background for both of those. What I will be talking about is why justice matters. A prominent component within the moral culture of our society as a whole is our employment of the language of justice, rights, being wronged, and their near synonyms. Call that the justice and rights component. A good many people employ that component only sparingly, and some are committed to never employing it. But if we look at our moral culture in its totality, we see that the justice and rights component is in fact one of its dominant components. It's by no means the whole. In addition to the justice and rights components, there is our employment of the language of duty, obligation, responsibility, guilt, and so forth. Call that, if you will, the obligation component. And there's the employment of our language of love, care, charity, benevolence, and the like. Call that, if you want, the benevolence component. And there's our employment of virtue language. Call it the virtue component. And these various components are interrelated in all sorts of different ways. Nonetheless, they're clearly distinct, so much so that one could imagine one component being absent while the others remain. So imagine the justice and rights component disappearing. None of us would any longer think and talk in terms of justice, rights, and being wronged. We would still think and talk in terms of love, charity, and benevolence. We would still think and talk in terms of duty, responsibility, and obligation. And we would still talk and think in terms of virtue. But the idea of justice would have disappeared from our minds. And the word justice and all its grammatical variants would have disappeared from our vocabulary. And likewise, the ideas of having a right and of being wronged would have disappeared from our minds. And the terms having a right and being wronged would have disappeared from our vocabulary. So here's the question that I'd like you to think about along with me. Would that matter? Would anything important have been lost? And if so, what? That's the question. The question, as I'm sure many of you realize, is not of mere academic interest. There are a good many voices on the contemporary scene urging that what I've invited you to imagine should in fact take place. Namely, that the justice and rights component of our moral culture be eliminated. From a number of quarters one hears it said, get rid of justice talk. From a great many more quarters one hears it said, get rid of rights talk. All of you have, I'm sure, heard that insistence. Now, I know of no case, there may be some, I know of no case in which the objectors ask what would be lost if we followed their advice. Their tacit assumption seems to be that nothing of any great importance would be lost. But an argument for getting rid of justice and rights that might be decisive if it were true that nothing of importance would be lost may be very far indeed from decisive if something of great importance would be lost. I want to argue this morning that some things of great importance would indeed be lost. To answer our question, why does justice matter, we must first spend some time getting clear on what justice is. Classic move of the philosopher, and I'm a philosopher. Lest there be confusion on the matter, let me say here at the outset that it's not the virtue of justice that I have in mind, but justice is something that characterizes certain ways of our being related to each other. Now, I've come to think that in the Western tradition, there are two fundamentally different ways of thinking about justice. I call one of these the right order conception of justice, and the other I call the inherent rights conception. So let me set out on our inquiry by explaining what I see as the difference between those two ways of thinking. And let's begin with the right order conception. One of the best examples from the past of this way of thinking about justice is Plato's Republic. In our days, one of the best examples is John Rawls's theory of justice. The right order theorist holds that a society is just insofar as it is rightly ordered. That is, insofar as people do the right thing. And he holds that whether a society is rightly ordered, whether people are doing the right thing, is determined by the degree to which the society conforms to some external standard. In Plato's case, that external standard was the Platonic form, the just thing itself, or in some other passages in Plato, justice itself. In John Rawls's case, that external standard consists of principles of fair distribution. Joan Lockwood O'Donovan, another person in this right order tradition, calls that external standard, I quote, an objective matrix of obligations. And yet others who are thinking along these lines say that it's natural law. That's what a Thomist would be inclined to say. Some right order theorists speak not only of the right thing to do, or doing the right thing, but they take the next step of talking about the rights that we possess. Rights now in the plural. Doing the right thing is in the singular, obviously. They speak about rights that we have. And these are often misleadingly, in my view, but anyways, these are often called subjective rights on the ground that they attach to a subject, to a person. If such people do speak of rights, right order theorists think of these as bestowed on persons by those principles of fair distribution, by the matrix of objective obligations, by natural law, by some body of legislation, by the Platonic forms, or whatever you prefer for your objective standard. So let me explain how this bestowal of rights, in the plural, goes when one thinks of the objective standard along John Lockwood O'Donovan's lines as objective matrix of obligations. The matrix of objective obligations consists, on her view, of general laws of obligation. General. It specifies how X-type persons in X-type situations ought to treat Y-type persons in Y-type situations. Completely general, purely in terms of types. But now suppose it turns out that I am an X-type person in an X-type situation, and that you are a Y-type person in a Y-type situation. Then, of course, when you apply the objective matrix, what it says is, I ought to treat you in whatever is the specified way. I ought to treat you. Suppose the application of the objective matrix to me and to you tells me, that I ought to help you cross the street. Then, so it said, corresponding to my obligation to help you cross the street is your right to being helped by me to cross the street. You've now got that right. What accounts for your having that right with respect to me, what accounts for it is my having that obligation towards you. Your right is derived from the obligation. It's the obligation that's the basic moral phenomenon. And once again, what accounts for my having the obligation is that I fit the X-type slot and you fit the Y-type slot in that objective matrix. Your being a human being of a certain sort and my being in a position to help you, here's the point. Your being a human being of a certain sort and my being in a position to help you is not enough for you to have the right to my helping you cross the street. In particular, your having a worth of a certain sort is not yet enough for accounting for your right to my helping you cross the street. No matter what type you are, no matter my situation, that's enough. In addition, there must always be that objective standard matrix, set of principles, whatever, that bestows on me the obligation, and then derivatively on you the right. Indeed, on this way of thinking, your having a worth of a certain sort may simply not enter the picture. in most natural law theory, it does not enter the picture. In Plato's theory, it doesn't enter the picture. Strictly speaking, it doesn't enter the picture in Plato's theory or any of them. Your having a certain worth may just play no role in how the objective matrix of obligations characterize those who fit what I've been calling that Y slot. Okay, hope that's somewhat clear. Now for the alternative way of thinking about justice that I call the inherent rights conception. The inherent rights theorists hold that just being a human being of a certain sort is enough to give one certain rights. And he holds that at bottom a society is just insofar as its members enjoy those rights, insofar as its members are rendered those rights. The rights are inherent in human beings of a certain sort. They just come along with being a human being of a certain sort. They're not bestowed on such human beings by some principles of distribution, by some matrix of obligations, by natural law, or by anything else of the sort. As you would expect, inherent rights theorists disagree with each other as to what it is about human beings that gives them these non-bestowed inherent rights. And we'll be getting into a little bit of those disputes shortly. But they all agree on this. Just being a human being of a certain sort is enough to give you rights. An influential writer on these matters was the German emigre, philosopher and political theorist Leo Strauss, who spent his mature career at the University of Chicago. In his 1953 book, Natural Right and History, Strauss takes note of the distinction between the right order way of thinking and the inherent rights way of thinking, and he argues that a hallmark of the passage from pre-modernity to modernity was the shift from the right order way of thinking to the inherent rights way of thinking. Let me quote what he says in one place. He says, the pre-modern, there you have it, pre-modern natural law doctrines, so he's thinking of the objective order in terms of natural law. The pre-modern natural law doctrines taught the duties of man. If they paid any attention at all to his rights, they conceived of them as essentially derivative from his duties, which is exactly how I describe it. You get the duty first and then you get the derived right. He goes on, as has frequently been observed, in the course of the 17th and 18th centuries, he's thinking especially of Hobbes and Locke here, a much greater emphasis was put on rights than had ever been done before. One may in fact speak of a shift of emphasis from natural duties to natural rights. But quantitative changes of this character become intelligible only when seen against the background of a qualitative and fundamental change. And the fundamental change was from an orientation by natural duties to an orientation by natural rights. That's Leo Strauss. Now, recent scholarship has shown that Strauss is simply mistaken in the historical claims that he makes in this passage. Recent scholarship has shown that the canon lawyers of the 1100s were explicitly using the concept of rights all over the place. And the reason this has mainly missed historians of philosophy is that it was the lawyers who were doing this and not the philosophers, and philosophers are not typically histories of legal practice. What's also the case, John Whitty has shown this, Whitty is at law school at Emory, is that the early second generation Reformed theologians and reformers in the Reformed tradition were, you may as well say, profligate in their appeal to the notion of rights. But for my purposes here, an interesting historical question, why the amnesia on these two scores? Why did the amnesia set in? But for my purposes here today, what's important is not that historical error, though I, as you may have gathered, feel strongly about it, but rather Strauss's clear recognition of the difference between the right order way of thinking and the inherent rights way of thinking. Now, my own conception of justice is the inherent rights conception. Every version of the right order way of thinking with which I am acquainted faces what seems to me insuperable difficulties. On this occasion, I do not intend to spell out those difficulties. I think it would threaten to be boring, and in any case, it's not necessary for our purposes here. Look, if I can present to you a plausible account of rights as inherent, then all accounts of rights as bestowed are just sort of otiose, unnecessary, beside the point. So that's what I'm going to turn to now. And I should say in advance that it's what I call primary justice that I'm going to be talking about, not what I'm inclined to call reactive justice. Reactive justice becomes relevant when there has been a breakdown in primary justice. It consists of the rights one acquires by virtue of being wronged. The right, for example, to be angry at the person who wronged one, the right to support as being punished, at least sometimes, and so forth. A comprehensive theory of justice would, of course, give an account of both that primary justice and then the reactive justice, the justice that becomes relevant when there's been a breakdown in primary. But here my eye today is going to be exclusively on primary justice. I call it reactive justice rather than retributive justice, as it's ordinarily called. Because I think the New Testament forbids retributive justice. That's one reason. It does not forbid punishment, but it forbids punishment understood as paying back, as getting even. A well-known formula for justice handed down to us from antiquity comes from the ancient Roman jurist Ulpian, opening Justinian's law code. Justice, said Ulpian, is rendering to each his or her, I'll use the Latin, use, J-U-S, I-U-S, J-U-S, use. That is, a little bit of ambiguity of translation, rendering to each his or her right or due. So Ulpian's formula is a formula for the definition of the virtue of justice. But from the formula we can infer, obviously, how Ulpian thought of justice itself. Justice is present in society insofar as each person is rendered what he or she has a right to. Now notice that Ulpian is tacitly distinguishing between having or possessing a right, on the one hand, and being rendered that right on the other hand, or as I will sometimes say in a somewhat old sense of the word, English word enjoy, enjoying that right. Not being rendered one's right does not mean that one does not possess the right. It means rather that one is not enjoying a right that one possesses, that one is being deprived of it, that one is being wronged, not rendered it. If one has or possesses a certain right, then one may either be rendered it, enjoy it, or not, be wronged. In the former case, one enjoys that to which one has a right. In the latter case, one is, as I say, wronged. So being wronged is the dark side of having a right, just as guilt is the dark side of obligation. The person who does not enjoy her right is wronged. The person who doesn't do what he ought to do is guilty, but he still ought to do it. Now, to have or possess a right does not consist of standing in the relation of possession to some mysterious, invisible little entity called a right. It would never have occurred to me to make this point had I not bumped up against some misunderstandings on the issue. That I discovered that some people think of rights as invisible, metaphysically mysterious little entities that we have a relation to, and then people say, oh, and they get in between us, these little things called rights. It is always to something that one has a right. You never just have a right, period, to some little mysterious thing. One stands to something in the relation of having a right to it. The whole term, having a right to, expresses the relation. The indefinite article, a right, doesn't do any work. Just as the definite article, the, does no work in the phrase, for the sake of. When you hear for the sake of, you don't think of there being little sakes, and now you're picking out one of these sakes. We might as well say having right to so-and-so. And skip the indefinite article. The relationship is, of course, a normative relation. Specifically, to stand to something in the relation of having a right to it is to stand to it in the relation of having legitimate claim to it. Or to express the idea in yet a third way is to stand to it in the relation of as being due one. So let us first consider the sort of thing to which one can stand in that normative relationship, and then consider the character of the relationship itself. I think that to which one can stand in the relation of having a right to it is, in the first place, always some state or event in one's life that would be a good thing in one's life, a life good. We don't have rights to evils in our lives. A right to something that would be a life good. Admittedly, it's always not evident from how we speak about rights that this is true. We speak, for example, of having a right to a seat on the plane. And a seat on the plane is not a state or event in somebody's life, it's a seat on the plane. But I think that if we look beneath the words to the structure of the situation, we'll see that what I said is true. When we refer to a right to a seat on the plane, we can more fully describe it as the right to take a seat on the plane. What we refer to as a right to and taking a seat on the plane is an event in one's life, obviously. More specifically, it's an event that would be a good in one's life. Of course, a philosopher or two here is inclined to say, well, yeah, but enjoying one's seat to take a right to take a seat on a plane might have disastrous consequences. The plane might crash. Yep. In that case, the whole package, taking a seat on the plane and the plane's crashing, is a bad thing. But that doesn't make the thing itself, taking a seat on the plane, a bad thing. And now for a very important step in the argument. Those life goods to which one has a right are always, I think, ways of being treated. That to which we have a right is always a way of being treated that would be a good in one's life. Normally, it's to the good of being treated a certain way by other people, but in the limiting cases, to the good of being treated a certain way by oneself. I think we can wrong ourselves. But it's going to simplify our discussion if I set that, wronging ourselves, off to the side, important as it sometimes is, and say that some life good to which one has a right is always to the good of being treated a certain way by one or more of one's fellow human beings. Here, too, it's not always evident from our way of speaking about rights that that's true. I have a right to walking on the Charlottesville pedestrian mall, but my walking on the mall is not a way of being treated, it's something I do. But I think, again, if we look beneath the words to the structure of the situation, we'll see that my right to walk on the mall can more fully be described as my right to be free to walk on the mall without hindrance. And that's a way of being treated. And so, too, though taking a seat on the plane is something one does, not a way of being treated, the right in question can more fully be described as the right to be allowed to take a seat on the plane. And that's a way of being treated. So pull some things together. Earlier I said that rights are normative relationships. What we can now add is that rights are normative social relationships. That to which one has a right is always to the good of being treated a certain way by one's fellows. It takes two, at least two, to have a right, with the exception of those cases in which you've got a right against yourself to not become an alcoholic and drug addict and so forth. So if Ulpian was right, justice is rendering to each what is his or her right or duty, due. If Ulpian was right, and I think he was, then what can now be said is that justice is present in society insofar as members of that society stand to each other in the normative social relationship of being treated as they have a right to be treated. Some of you will discern why I'm hammering home the point of the sociality of rights, to oppose the utterly common idea that somehow rights is ideas intrinsically connected to individualism, possessive individualism, and so forth. I think that depends on a misconstrual of what rights are. They are being treated in certain ways by our fellows. Well, now we face what I regard as probably the greatest challenge for anyone trying to construct a theory of rights, namely, explaining the nature of that normative social relationship of having a right to. Here's the challenge. Though that to which one has a right is always a way of being treated by one's fellows, that is or would be a good in one's life, the converse is not the case. There are many ways of being treated that would be a really good thing in my life, but to which I don't have a right. The Rijksmuseum in Amsterdam possesses many glorious Rembrandt paintings. I think the most glorious is the Jewish Bride. I think it would be an enormous good in my life were the Rijksmuseum to offer me the Jewish Bride to hang on my living room wall, along with a substantial security force to guard it. That would be a great good. Yeah, and you could all come and see it, provided you didn't touch it, of course. But I don't have a right to that life good. I'm not being wronged by the museum by their not granting me that great good. So what accounts for the fact that of all those ways of being treated that would be good things in one's life, one has rights to some of them, and others would be nice, but you can't say that you've got a right to them, that you're being wronged by not enjoying them. Well, obviously some of our rights are bestowed on us by legislation or social practice, or are generated in us by some such speech act as promising. I have a right to receive a monthly Social Security check from the US government on account of the Social Security legislation passed in the 1930s, plus, of course, the fact that I fit the qualifications specified in the legislation. But not all rights are like that. Some are natural rights. Wholly apart from legislation, social practices, and speech acts, I have a right not to be murdered, to not being tortured for the pleasure of the torturer, to not being insulted or demeaned, even if it were the case that we couldn't point to some law. So what accounts for the fact that of all those ways of being treated that would be good in one's life, one has a natural right to some of those ways of being treated, while to others of those ways, one doesn't have a right. The view on this point that is presently dominant in the philosophical and political theory literature is that natural rights have something to do with personal autonomy. The phrase "something to do with" is, of course, vague. And in the literature, one finds various ways of eliminating the vagueness. Here is not the point for me to canvass that variety. Let me select, so that you see the idea, one common way of eliminating the vagueness, and then show why it does not give us an account of rights. The problems I'll point to will include taking note of certain counterexamples, and these counterexamples pose problems for all attempts that I know of to account for natural rights in terms of autonomy. So here's how some writers understand the vagueness in the phrase, eliminate the vagueness in the phrase "something to do with autonomy." They observe they say that let's understand autonomy as forming for oneself a plan of life, enacting that plan, and revising it along the way as seems necessary. And then they say personal autonomy, so understood, enacting a life plan, is an intrinsic good of great importance, and is then proposed that one's natural rights be understood as protections of that great intrinsic good of personal autonomy. If being treated a certain way would infringe on one's autonomy, then one has a right to not being treated that way. Get the idea? This is the view that Oxford philosopher James Griffin develops in his recent book on human rights. The exercise of autonomy, he says, is an intrinsically, I quote him, intrinsically valuable component in one's life that has special importance in determining the worth of one's life. And it's because of that special intrinsic importance that we do what he calls ring fence, a kind of nice metaphor. We ring fence autonomy with the notion of rights, ring fence, so that infringements of autonomy are violations of rights. An implication of this way of thinking not noted by Griffin is that autonomy, on this view, is not just an important intrinsic good, but that in fact we have a right to the exercise of our autonomy. A right not just to the things that ring fence it, but to it itself. And that this is, in fact, has to be the fundamental right. Look, if I've got a right to my autonomy not being infringed on, then it must be that I've got a right to the exercise of my autonomy itself. So one problem confronting this theory of rights is explaining what the purported right to autonomy amounts to. Clearly, nobody has the right to do whatever he or she sees fit. So what then is this purported right to autonomy from which all other natural rights are thought to flow? I judge that no autonomy theorist has succeeded in answering that question. But it wouldn't serve our purposes here for me to delve into that. More important, Griffin now owes us an explanation of why we have a right to autonomy. The theory says that I have a right to freedom of speech because to limit my freedom of speech would be to infer on my right to autonomy. Yeah, but what accounts for my right to autonomy? The fact that it is a great intrinsic good in my life does not imply that I have a right to it. Remember that great intrinsic good, which would be that Rembrandt painting hanging on my living room wall? So there are various attempts in the literature to explain why we supposedly have a right to autonomy. I don't think any of them work, but once again, I'm not going to run you through it. Instead, I want to conclude this part by just pointing to some counterexamples. I think they're clear counterexamples to the thesis that all natural rights are protections of autonomy. I dare say that everybody listening to this talk will agree that to torture imprisoned criminals as a way of punishing them is to wrong them. They have a right not to be punished by torture. But I submit that what makes it wrong is not that their autonomy is thereby, is that the torturing impairs their autonomy. Their autonomy is already thoroughly impaired. They're locked up. They can't implement a plan of life. A related example is the following. I'm told that within a good many legal jurisdictions in this country and in Europe, it is forbidden to shackle prisoners when they appear in court, unless they threaten to act violently. I think that's really interesting. But what's wrong about shackling them cannot be that that infringes on their autonomy. Their autonomy is already thoroughly limited by that cordon of burly policemen standing around them in the courtroom. There's nothing that shackling them adds by way of inhibiting. An example of a rather different sort is this. Suppose that I invade your privacy for purely prurient reasons. I do nothing with what I discover other than that I enjoy it in my privacy at home. I have wronged you, but I have in no way infringed on your autonomy. Or suppose I badmouth you behind your back, but that this bad-mouthing has no effect on how I and others interact with you. We just, laugh to each other, but we treat you the same way. I've wronged you. But again, I have not infringed on your autonomy. A final example. I hold that human beings in the final stages of Alzheimer's disease have rights. They can be wronged. To take the most gross case, they have a right not to be poisoned and their corpses tossed into a dumpster for waste management to haul away. But wronging such a human being cannot consist of infringing on her autonomy, since she has none or very little autonomy left to be infringed upon. So if what's wrong about shackling a prisoner in court who threatens no violence, or torturing a prisoner, it's not that it infringes on his autonomy. What makes it wrong? I would say that what makes it wrong is that it humiliates and demeans him. And that's the point of doing it. It's wrong, always and everywhere, to demean someone. Wrong to do so even if they are guilty of a crime. To demean someone is to treat him with less than due respect. And it's wrong, always and everywhere, to treat a human being with less than due respect. So natural rights, as I see them, are grounded in worth, in dignity. Rights are what respect for worth requires. You have a right to the life good of being treated a certain way. Just in case were you not treated that way, you would be treated with less than due respect. Just in case your worth, your dignity, would not be duly honored. If torturing you is incompatible with treating you as befits your worth as a human being, in my view, bearing the image of God and beloved of God, then you have a right to the life good of not being tortured. If you are a student in a course that I'm teaching and you have acquired the worth of being someone who did top-notch work for the course, then you have a right to the life good of my giving you a grade that befits the worth of your achievement. In the American system, that grade is an A. If I don't give you an A, I do not treat you as befits your worth as a student in the course, and thereby I wrong you, deprive you of your right to an A. So rights, I hope you see, thus understood, represent an interweaving of life goods of being treated a certain way. Life goods on the one hand, with the worth or dignity of human beings, whose life goods those are, on the other hand, interweaving of life goods and worth. It follows that any ethical theory that works only with the concept of life goods, and not also with the concept of the worth or dignity of human beings, is incapable of giving an account of natural rights. Modern utilitarianism is one such theory that works only with the concept of life goods. It's my view that, controversial admittedly, that eudaimonism, currently enjoying a renaissance, is another. Look, one does not get rights by just piling up life goods. Being given a Rembrandt painting to hang in my living room would be an enormous good in my life, but I don't have a right to it. Being treated grumpily by the secretary in the health service, I'm thinking of an actual example here, being treated grumpily by the secretary in the health service is a small harm in my life. I was going to say I've recovered from it, but obviously I haven't quite recovered from it. But it's a small harm in my life. Nonetheless, if I have been so treated, I've been wronged. I've got a right not to be treated like that. So what accounts for the difference is not size of goods, of course, but is that by not being offered that painting, I'm not being treated disrespectfully, whereas by getting the snappy, surly answer from the secretary, I am. Incidentally, it's worth noting that all the UN documents on human rights explicitly ground rights in dignity and not in autonomy. Why does justice matter? Why do rights matter? What would be lost if the justice and rights component of our moral culture fell into disuse? I think two things of great importance would be lost. Let me introduce my explanation of one of these by describing the episode in which it first became clear to me that something of great importance would be lost if we could no longer use the language of justice and rights. In September 1975, I attended a conference at the University of Wolterstorff in South Africa, and Henk Hart, here present, was present at the very same conference. Potchefstroom is a smallish city located about an hour from Johannesburg. In 1975, the university was very much an Afrikaner university. In addition to the South African scholars present at the conference, let me use the classifications they used at the time: white, colored, black. In addition, there were scholars from other parts of Africa, a few other parts of Africa, a very sizable contingent from the Netherlands, and a few of us from North America. The highlight of the first day and a half of the conference was extremely angry exchanges between the Dutch and the Afrikaners. Recall that 1975 was well before the revolution in South Africa. The Dutch were very well informed about South Africa. They could understand Afrikaans, and the Afrikaners could understand Dutch, and the Dutch were very angry about apartheid. So even though the conference was not about apartheid, the Dutch seized, I think that's the word I want, grabbed every opportunity that they could find and opened some up that they didn't actually find to vent their anger at the Afrikaners. And the Afrikaners in response seized every opening they could find to vent their anger at the Dutch for being so judgmental. Normally the Afrikaners responded, but you don't understand the situation. The Dutch understood the situation very well, so the tactic was, why are you so judgmental? After a day and a half of this angry back and forth, neither party had anything new to say to the other. Actually, they had kept talking for about half a day when they didn't have anything new to say. And it was at that point that the so-called blacks and coloreds from South Africa began to speak up, more in tones of hurt than anger, or so it seemed to me. They spoke of the indignities daily heaped upon them, and of the degrading cruelties heaped upon them by the whole system of apartheid. And they issued an extraordinarily moving call for justice. The response of the Afrikaners to this call for justice took me completely aback. I expected them either to contest the claim of the blacks and the coloreds that they were being treated unjustly, or to excuse it. They did neither of those. Instead, they insisted that justice was not a relevant category for the situation. Benevolence was the relevant category. And when it came to benevolence, they said that they, the Afrikaners, were a charitable and benevolent people. Those present at the conference told stories of the benevolent way in which Afrikaners treated the blacks living in their backyards. They passed on clothes that their own children had outworn. They gave them small gifts at Christmas, the children, and so forth. And they insisted that the entire system of apartheid was motivated by benevolence. They pointed out that South Africa contains some 10 or 11 distinct nationalities, depending a little bit on how you count. And they insisted that the entire system of apartheid was motivated by social benevolence. That the system of apartheid was aimed at encouraging each nation to find its own cultural identity and to flourish in its own distinct and unique way. And this required that these nations, nationalities, be pulled apart, separated, apart, apartheid. And they went on to say that they and their fellow Afrikaners were deeply hurt by the fact that the blacks and the colored so seldom expressed any gratitude to the Afrikaners for their generosity, neither for their acts of individual generosity, nor for their acts of social political generosity. What I saw before my eyes was benevolence being used as an instrument of oppression. And I think it was the first time that I saw really clearly why justice matters, or one reason why it matters. The concept of justice enables us to put a brake, B-R-A-K-E, to put a brake on paternalistic benevolence. There's a lot of paternalistic benevolence in the world. Much of it, not all of it, profoundly unjust. The person in power saying, I know what's good for you. You may suffer a little bit, but I know what's good for you. It's on account of a feature of rights that I've not yet called attention to that justice has this breaking import. In the literature on rights, one finds the feature referred to as the trumping force, or sometimes the peremptory force of rights. And what's meant is that if you have a right to the good of being treated a certain way, then no matter how many good things I may bring about by not treating you that way, I ought to treat you that way. Return to the example of a student who has done top-notch work in a course I'm teaching, and who accordingly has a right to an A. And now that he's rather cocky and full of himself, and that I judged that a B- might result in some desirable character formation. So I give him a B- and highlight the flaws in his work. Parenthetically, professors who have taught for some years can find flaws in even the best student work. I'm describing here a case told me by one of my colleagues that he had in fact done this. To do that to the student would be to wrong him. He has a right to an A. And so it just follows that I ought to give him an A. If I think he needs some character formation, I'll have to find some other way of encouraging his reformation that doesn't involve wronging him. The 20th century was filled with political regimes which believed that it was acceptable to treat some people like animals if doing so would bring about some great good for others. If we cannot appeal to the rights of human beings, if we cannot argue that to treat human beings in such a way is to wrong them, to demean them, and is hence just off the table, we have no right to stop this calculus of goods mentality, this utilitarian, pragmatic mentality. For the sake of the argument, let's grant that the segregated society the Afrikaners envisioned, in which each nationality would find its own separate identity, would have been a good thing. I don't think it would have been a good thing, but for the sake of the argument, let's suppose it would have been. The massive injustice perpetrated on the so-called blacks and colors meant that achieving that ideal by apartheid was wrong, off the table, impermissible. The benevolent impulses of the Afrikaner did not excuse the injustice. The injustice trumped the benevolence. So once again, by virtue of their trumping force, rights put a brake on paternalistic benevolence. And now, lastly, for the second thing of importance that would be lost if we no longer had available to us the language of rights. Recall my declaration when I was explaining what a right is, that a right is always to some life good of being treated a certain way. And now notice, I used the passive voice, being treated a certain way. I submit that the moral order as a whole has two fundamental dimensions: the agent dimension, and in older English, the patient dimension, the actor dimension, and the recipient dimension. On the one hand, there's the moral significance of what we do, but on the other hand, there is the moral significance of how we are done unto. On the one hand, there is the moral significance of how we treat others, and on the other hand, there is the moral significance of how we are treated by others. In thinking about the moral order, it strikes me that the philosophical tradition has focused almost all of its attention on the agent dimension. Talked about responsibility, talked about rationality, love, and so forth. And I think in doing this, it has offered us a seriously incomplete and distorted picture of the moral order as a whole. Look, the language of duty and its companion language of guilt are for bringing to speech one aspect of the agent dimension of the moral order. The agent did what he ought to do, did not do what he ought to do, whatever. By contrast, the language of rights and its companion language of being wronged is for bringing to speech the recipient dimension of the moral order, the dimension of how we are done unto. Consider an abused spouse. And suppose that the only language available to her is the agent language of duty, obligation, love, and so forth. With such language, she can call attention to the moral condition of her abusive husband. He's guilty of failing to treat her as he ought to treat her, of failing to act lovingly, and all of that. What she cannot do with such language is call attention to her own moral condition. Namely, she's been wronged. Yes, he's guilty. But there's something more to be said. She's been wronged. Rights talk enables her to do that. I submit that it would be a great loss if she did not have available to her the language for calling to attention the moral significance of how she has been done unto. namely that she has been wronged. The reason rights language has usually been the preferred language for social protest movements is that such language enables the oppressed to call attention to their moral condition. Let's get at the same two-dimensional idea from a slightly different angle. In the case just imagined, we noted the difference between the abused spouse having only the language of the agent dimension available for describing the morality of the situation, versus also having available the language of the patient dimension. Okay, now imagine that you are reflecting not on how you've been done unto, but on how you yourself should treat some person or group of persons. What's the difference between thinking of the situation only in terms of the agent dimension and thinking of it also in terms of the patient dimension? What's the difference between thinking of the situation only in terms of your duty, your generosity, and the like, and thinking of it also in terms of the rights of those others? Suppose I'm a college professor. What's the difference between my thinking of the classroom situation wholly in terms of my responsibilities, my generosity, and the like, and my also thinking of it in terms of the rights of the students, the rights and the dignity of the students? I feel profoundly that there's a difference, but I don't find it easy to put into words the difference, but let me try. That second situation, orientation, that second orientation requires that I be open to the worth of the students in a way that the first does not. I become, as it were, a moral listener and not just a moral actor, open to recognizing your worth and to the claims that such recognition places upon me. The problem, as I see it with the Afrikaners, was that they were so full of their own goodness and virtue, supposed goodness and virtue, that they never opened themselves up to recognizing the worth and dignity of the so-called blacks and coloreds. Never opened themselves up to the question of whether they were demeaning them. They resisted moral decentering, resisted becoming moral listeners. They wanted to be in charge. They wanted their self-perceived generosity to be received with gratitude. And of course, they insisted that the so-called blacks and coloreds be on good behavior, or the generosity would not be forthcoming. That's how it is with generosity. That's what we're witnessing in the Middle East today, Israel and the Palestinians. Generosity can be conditioned. By contrast, the requirement that I pay due respect to you for your worth has no conditions, none at all. In closing, rights talk is often abused. It's abused when we talk about nothing but rights and never about responsibilities. It's abused when right ideals are couched in the language of rights, so as to make those ideals seem obligatory, and to make those realists who are skeptical about the attainability of the ideals feel guilty. Rights talk is abused when rights claims are accompanied by moral absolutism and no disagreement is brought. Look, judgments about rights are not infallible. They're often mistaken. And so it behooves us to listen with open mind to those who offer serious reasons for holding that we were mistaken in the rights claims that we've made. So too, rights talk is abused when it's employed by the possessive individualist to call attention to his rights, while riding roughshod over those of others. If rights are what I've said they are, normative social relationships, grounded in the worth or dignity of human beings, and consisting of a legitimate claim to the good of being treated a certain way, then it's clear that that's an abuse of rights talk. Between me and the other, there is a normative social bond, whereby she bears legitimate claims on how I treat her, and whereby, yes, I bear legitimate claims on how she treats me. The situation is entirely symmetrical. And the language of rights is for bringing that to voice. All components of our moral vocabulary are subject to abuse. The obligation component is abused by the authoritarian husband who preaches to his wife her duty to obey whatever he tells her to do. If abuse of some component were sufficient reason for getting rid of it, we would have no moral vocabulary left. Of course, if nothing of importance would be lost, then abuse of some component, depending on how serious it was, might well be a sufficient reason to get rid of it. But we've seen that two things of great importance would be lost if we no longer had the language of justice and rights available. We would not have available to us the conceptuality to put a brake on paternalistic benevolence, and we would not be able to bring to speech the patient, the recipient dimension of the moral order. So justice matters deeply. Matters because rights matter. Not the only thing that matters, but matters deeply. And rights matter because our worth and dignity matters. It matters whether a human being is demeaned, degraded. It matters whether one is treated with due respect for one's worth and dignity. Injustice is indignity. That's what's wrong with it.